Unfortunately, even though we have provided guidelines on how this can be done in our rulings, practitioners still have difficulty complying with the rule, resulting in the shipwreck of their cases. One area of concern we have observed is filing in court processes that have grammatical errors and also typographical mistakes. We have so many of such cases coming up before us, and I think the solution is devoting time to reading those documents before filing. Also, it is good practice for legal practitioners to seek the support of other lawyers. At the law school, we are taught that it is not right for a lawyer to prepare a document and take it out to the public, share it with another colleague or even a third party, because they could see things you did not see, and that could redeem that document. Then for lawyers appearing before the National Industrial Court, you must know the rules of this court. There is the Practice Direction 2022, which is called the National Industrial Court of Nigeria, filing of applications, motions in trade union matters, and marking of exhibits. Practice Directions number 1 of 2022. Lawyers appearing in this court must be familiar with this practice direction. Unfortunately, even though we have provided guidelines on how this can be done in our rulings, practitioners still have difficulty complying with the rule, resulting in the shipwreck of their cases. The other sad thing we have observed is copying the pleadings verbatim into the witness deposition. In fact, in preparing for this section, I had to lift one pleading, which permit me to share it here. In one of the cases I handled, I'll read. Counsel pleaded in paragraph 1 of the statement of facts inter alia, and I quote, "The claimant pleads and shall at the trial of the suit rely on the employment contract," end of quote. In paragraph 1 of the witness statement on oath, he stated inter alia, "I shall at the trial of the suit rely on the employment contract." You can see that. So automatically the pleading is also the witness deposition. So where is the evidence? And the court is obliged to sift between the two documents what the evidence is to ensure that justice is done. And that is the burden the courts have in ensuring that a litigant is not denied justice before the court. And I have some things that we can look at as suggestions. In preparing for a case, the first thing to do is looking at the merits of the case. When we began practice, one of the things our principals will ask us to do when we have a brief is write a legal opinion. I don't know if that still happens today. And in writing a legal opinion, you will need to look at the law relating to that case, the strengths of that case, if you're for a claimant, the likely defenses your opponent will profile in the case. And then you advise your client and you write it down. It is in the file. So even though you are not the lawyer handling the case, whoever takes that case has a foundation upon which he can do the case.